comprehensive reproductive care must remain free to seek that care in states where it is legal. In Justice Kavanaugh's words, this question is, quote, not especially difficult. Our brief explains that the threatened Alabama prosecutions infringed the constitutional right to travel. It also makes clear that states may not punish third parties for assisting women in exercising that right. We are also continuing to litigate the suit we brought to ensure that women in Idaho have access to the emergency care guaranteed by the Federal Emergency Medical Treatment and Labor Act, or EMTALA. Idaho's law prohibits abortion even when it is the medically necessary treatment to stabilize a patient's emergency medical condition. Last week, we filed a brief in the Supreme Court to preserve an injunction that blocks Idaho's law to the extent it prohibits doctors from providing the care that is required by EMTALA. The Justice Department will continue to vigilantly monitor laws and actions that infringe on federal protections of reproductive rights, and we will take appropriate action to defend those rights. We are also continuing to advise federal agencies on legal issues related to reproductive health in the aftermath of Dobbs, and we are defending agencies as litigation arises. More than 2 decades ago, the Food and Drug Administration approved the drug mifepristone as safe and effective to terminate early pregnancies. But in an unprecedented decision issued earlier this year, the District Court for the Northern District of Texas displaced the FDA's expert judgment and blocked the agency's approval of mifepristone. We quickly obtained a stay of that decision from the Supreme Court while the case is on appeal. And now that the Fifth Circuit has affirmed the District Court's decision in part, we are seeking Supreme Court review to ensure that mifepristone remains available on the terms approved by the FDA. The Department of Justice will not cease its efforts to preserve access to mifepristone and defend the FDA's expert judgments. Finally, we continue to work to protect healthcare providers and people seeking reproductive health services. We continue to enforce the Freedom of Access to Clinic Entrances Act, known as the FACE Act. That law prohibits anyone from obstructing access to reproductive health services, including abortion services, pharmacies that provide reproductive health care services, and pregnancy counseling services, through violence, threats of violence, or property damage. We are working to ensure that prosecutors across the country are equipped to bring FACE Act cases, and we have emphasized that Civil Rights Division attorneys are always available for consultation and technical assistance. All of this important work has been done and coordinated by the dedicated public servants on the Department's Reproductive Rights Task Force, and it has been led by Associate Attorney General Vanita Gupta. I'm deeply grateful to Vanita for her extraordinary leadership, and I'm likewise grateful to the professionals across the Department who work every day to uphold the reproductive freedoms guaranteed by federal law. Together, we will continue to fulfill the Department's founding responsibility to protect the civil rights of all Americans. I'm looking forward to this afternoon's briefing. Vanita, would you like to make some remarks before we begin?
Sure. Thank you, Attorney General Garland. I am grateful for your clear-eyed leadership and continued support on these issues. And thank you to the members of the Reproductive Rights Task Force. 18 months into this effort, you and your components across the department continue to work creatively and relentlessly to use all of our available tools to protect reproductive rights, health, and justice. There is no understating the devastation wrought by the Dobbs decision. It has impacted people and communities across the country, with the effects falling hardest on low-income people, people of color, and other vulnerable populations. With each day that passes, we see reports of new actions by states, not only to restrict access to abortion within their jurisdiction, but also to chill women from seeking abortion and other reproductive health services, even where they remain lawful. We established this task force as a whole-of-department effort to closely scrutinize these new, complex, and widespread threats to reproductive health for any infringements on federal protections. As the Attorney General has highlighted, we have not hesitated to act to vindicate those protections, be it through affirmative litigation, the Department's ongoing FACE Act enforcement, and other work advising and defending the actions of federal agencies such as the FDA in multiple challenges to the abortion medication mifepristone. Among the emerging threats that we are closely monitoring are actions of states like Alabama that infringe on the constitutional right to travel across state lines to obtain reproductive care that is legal in the destination state. The Civil Division's recent filing makes clear that states may not criminalize third-party assistance for such interstate travel, particularly where the sole purpose of threatened prosecutions is to impede individuals' exercise of their constitutional rights to travel. Our work on these matters is doubtless ongoing, but we remain committed to doing all that we can to defend the constitutional right to travel, among other federal protections for reproductive freedom. Thank you.